So until Monday and our various governments and legislative assemblies turn around and tell us what our timetable is looking like, and until we get absolute clarity on what the new furlough rules eligibility might look like, then I think it's time to move on to just some questions that have been coming through. And we have summarised these in slides. I heard Rodney confirm that these slides will be released in due course, and this session is being recorded and will be released, so that's no problem. I suppose the caveat that we would need to say is that while Jonathan and I are employment lawyers, the following is commentary. It's like a legal clinic as opposed to absolute full-blown legal advice all the way through. For us to do that properly, or for anyone to do that properly, you need to bear in mind a couple of underlying pieces. First, the Chancellor himself, when he announced this, said that underlying principles of employment law are not affected by the job retention scheme and furloughing. Consequently, you cannot rely absolutely on UK government guidance in relation to the furlough scheme. Employment consent is critically important, and the reason why that's important is it's a huge nod to the fact that employment law principles still apply. So how we select, how we communicate, how we apply still must not be discriminatory in any form. We still must, as employers, be able to objectively justify all our decisions, and we should have clear communications and a good paper trail. Bearing that in mind, these answers are answers that we will give in relation to questions posed, but to get the full extent of the proper answer, you probably want to take your own independent legal advice and make sure that you go armed not just with the question, not just with your understanding of the JRS scheme, but also the employment contract which rides behind this, combined with all communications issued by the employer to the employee in question. Without those various sources in tow, you will only get a partial answer to this. So with that in mind, we'll kick straight in. So can you clarify if a shielding worker is entitled to SSP, and is this recoverable through the scheme beyond 2 weeks? So we have set out most of the answer there. So employees who are unable to work because they're shielding in line with public health guidance can be furloughed, and 80% of their wages up to £2,500 per month can be recovered through the scheme. So the key word in each there, which I put emphasis on, is the word can. Furloughing was not originally designed for shielding or shielded workers. It was originally designed for employers or employees who were facing redundancy. A shielding or shielded worker may not necessarily be facing redundancy, so consequently, is an employer obliged to put them into furlough? The answer to that is no, but they are strongly encouraged to, as long as they are genuinely shielded or shielding in line with public health guidance. And that clue with public health guidance, again, refers right back to the NHS letters which were issued. There were anecdotally around 1.5 million of those letters issued. Everyone knew that they were going to miss certain people, but employers are still being faced with a really difficult position whereby you receive a letter from a local GP practice, which is a 4-liner, which uses some of the terminology used about consideration as to whether someone is vulnerable or extremely vulnerable. And some GPs are also writing letters saying, in their opinion, they think someone should be furloughed. That, frankly, is not necessarily good enough. It is 1,000,000 miles away from the NHS letter, and it is not close to the British Medical Association guidance approved and issued to GP surgeries and practices. So there is a small risk that if an employer accepted a GP letter on the face of it without any further investigation and put that individual into furlough, there's a possibility that individual will not be accepted for JRS by HMRC, or subsequently HMRC may come back and investigate and say, look, this person wasn't properly shielded stroke shielding, consequently we're going to recoup. That puts the employer in a dreadful position because they have paid out the monies, and who is going to pay that back to HMRC? It'll be extremely difficult to recover it back from the employee in those circumstances. in which case the liability will probably fall on the employer, and the employer will then have to work out a repayment plan with the employee, who may not even be their employee anymore. So you can see some of the difficulties arising. So before we commit to accepting someone as being eligible, do your own review of their status, what you know. Maybe ask for further clarity from occupational health or a better, more substantive letter from their GP, and then apply it. But in any event, you will need to get their consent as well and point out some of the concerns. So second part, what happens if the shielding employee who is furloughed becomes sick? Well, they retain their statutory rights, including the right to statutory sick pay. Statutory sick pay was extended in relation to the furlough period as well for an additional 2 weeks because of self-isolation and COVID, etc. It was an unusual scenario, so the government moved quickly to put in an extra 2 weeks SSP for that. But it will be up to the employer to decide whether to move an employee onto SSP or to keep them in furlough at their furloughed rate. Because if a furloughed employee who becomes sick is moved onto SSP, employers can no longer claim for the furloughed salary, and moreover, you cannot claim for SSP and furlough. It is one or the other, and the employer will have to make the election, because it is the employer who makes the application through the HMRC Government Gateway each time, not the employee. The employee may tell the employer what it would like to see or hear, but it's the employer's decision, and consequently the liability rests with the employer post as well. So we'll go to the next question. We are a key business. Can we enforce a return to work to the office after lockdown? The very short answer to that is yes, and this is true for all businesses, whether it is a key business or not. After lockdown and after furlough, the employer can require the employee to return to work effectively immediately. The only issues really that come into that are the underlying guidance from public health, health and safety generally, and an awareness that in the post-lockdown climate, I think all of us will be more reticent to attend public gatherings. We will be more reticent to be around colleague employees if they're small office spaces or small workplaces, etc., particularly if someone is showing symptoms. Now, this is ridiculous, but it could be as simple as someone having hay fever, but you just know that in this climate now, people will be a lot more cautious, and they won't necessarily be cautious for themselves. They may be perfectly healthy, etc., but they may be very wary of attending work and then bringing back an illness to when they next visit one of their aged parents or someone who is in the extremely vulnerable category. So employers need to be very, very aware of that. So the short answer is yes, you can enforce a return to work to the office or to the place of work after lockdown, but you have got to do it hand in glove with reassurance to employees in relation to health and safety, etc. And there's both a carrot and stick to that. The carrot obviously is returning to work and returning to full rate of pay, and there are all of the upsides to work and the workplace that we maybe didn't appreciate, but social interaction, etc. But the stick also is, if an employee refuses and unreasonably refuses to return to work, then again normal employment law practices apply, and that can lead to a disciplinary action. Next question then. When can we expect to know if there will be an extension to JRS to those businesses in the tourism and hospitality sector? Well, this is where I veer into a little bit of theorizing based on what we have heard, and you have to bear that in mind. We expect that the furloughing scheme is going to change after the 30th of June. It was confirmed that it will be reviewed and extended. That was this morning. UK government said it would be reviewed and extended if needs be. So the JRS scheme will exist, I think, in some way, shape or form after 30th of June. Everyone has talked about the cliff edge and trying to avoid that. But equally, the government has also confirmed, and everyone accepts, it's unsustainable, not just in Northern Ireland, but throughout the UK. and consequently there is a desire to look towards a lifting of the lockdown measures, a gradual return to work, and consequently a gradual removal of the JRS scheme. It's likely to be retained only for those industries hardest hit, particularly tourism, hospitality, as I've mentioned, but it is also even for those industries likely to be reduced in relation to the monies paid. It won't be 80% 2.5k indefinitely, and how and to what extent they introduce means testing, we don't yet know. So we're in that little bit of a lull period in the absence of confirmed information. We'll see something out of the Northern Ireland Executive hopefully by the end of today. Don't expect anything magic in that. Even if they talk about principles in relation to moving out of lockdown, I don't imagine there will be any firm dates, not like the ROI scheme, which has set out dates between now effectively and August, all of which are conditional in any event. And because everyone is still waiting on the medical and scientific evidence and fearful of a second surge, you can see that no one is going to commit to anything just yet. My last point on this slide, the Northern Irish Executive, a lot of the ministers are beginning to make noises about particular industries, but one in particular, which is secondary to tourism and hospitality, which is baggage handlers at the airports, then maybe they will need to also avail of a reviewed and diluted scheme post the end of 30th of June. But for all of us who are outside that particular sector, two things. One, assume that it's not going to go in its current form beyond 30th of June. Two, if that means, and it's a negative conversation to have, but it's a reality, if that means that without the comfort blanket of the JRS, as a business we will need to make redundancies, then those considerations should begin now, because consultation, timetables, advice, etc., finding out all the alternatives to compulsory redundancy, that should be explored now. You should not wait to the end of JRS and then run it. It would be prudent to at least begin the dialogue now internally, and if needs be with your members of staff. So next question, what is the process if you claimed an incorrect amount in your first claim? Can the underclaimed amount be added to a second claim? Short answer to that is no. Employers must claim for all employees in each period at one time. You cannot make changes to the claim, and if you underclaim and you make a mistake in your first round, then there's no recourse communicated at present. There may well be and will be at some point some appeal structure and ability, but at the minute the portal is all about paying out. It is not about going back over those amounts which you just paid out and dealing with anomalies. It's just there's no capacity to do that yet, and consequently there's no recourse. And certainly what is also clear is that you cannot self-remedy by making an overclaim for the second period, because an overclaim will be considered as a fraudulent claim, and guidance is there that says if we make an incorrect claim which is over, we have to tell HMRC immediately and refund the incorrectly claimed amount to them. So there is no ability to self-remedy in this scheme yet. If we have made a mistake in the first claim, in a sense that's tough. We need to make sure that we make sure all subsequent claims are rectified, and make sure we keep a detail of the first claim error, and in due course seek to recover that from HMRC. I don't imagine you will ever get cash back from HMRC for that. What they will probably do is factor it into your year-end accounts and your VAT bills, etc. in due course, but that is a matter for your payroll and for your accountant to keep on top of for you as we move through this and some clarity comes in. Straightforward enough, even if it's a relatively negative answer for you. So next question, why are new starters not included? Well, there has to be a cutoff date somewhere. The government was very concerned about what they call ghost employees, i.e. they were concerned about employers taking advantage of the scheme and putting in names, details, etc., or even hiring people, contacts, etc., to try and get them 80% of the 2.5k inappropriately. So there has to be a cutoff, and some new starters will be left out of this. Ultimately, that is a very small percentage of the overall workforce generally, and there will always be some people left out of this scheme who just don't benefit, and that is effectively what it is. Those new starters are still able to return to their previous employer and ask to have been to be furloughed. So that ability is still there, even if it's unusual, subject to PAYE and RTI information being there to support that application for the relevant date. So we'll go to the next question. We are interested in the flexibility of turning on and off furlough for different staff to ensure business remains healthy. So this is a great question, and employers should be encouraged to see the furlough scheme as being really quite a flexible scheme. Employers can turn furlough on and off dependent on business need. They can also turn furlough on and off for different staff to ensure business remains healthy, but also to ensure that there's no stigma attaches to employees who've been furloughed, that they are rotated with colleagues, so that everyone gets the benefit and also gets the opportunity to continue to keep their skill set high and contact with clients, customers, etc., etc. So the conditions that attach to that are that any employee can be furloughed multiple times, but each separate instance must be for a minimum period of 3 consecutive weeks. And every time you want to put someone out on furlough and then bring them back and then out again, you should get a separate consent for that. If we put an employee out on furlough for 3 weeks or more and business need changes and we want to bring them back, unless they have been out for a minimum of 3 weeks, we will lose the benefit of that. So there is a commercial call to this. If you bring someone in to do any work during that 3-week period, they're no longer furloughed, they're working, and you lose the benefit. For the entire 3-week period, or the 2 weeks and 4 days they were out, you can't partial furlough and claim only for the few hours that they actually worked for you. You're either furloughed or you're not. The categories of work that are permitted, we've talked to before. The guidance is pretty clear. An employee cannot generate revenue for or provide service to their employer whilst on furlough. They can pick up a second job, a temporary job, and generate revenue for a third party, or provide services to a third party. That will not offend their furlough claim. And equally, some employers are saying, can we ask our employees to work for us on a voluntary basis? No, that's just a cute way to try and get around this. They may work voluntarily for you, but they are either generating revenue or providing a service, which is against the furlough scheme. So short-term gain, long-term hit, because HMRC will come back, and that's precisely the kind of activity that they will consider fraudulent or opportunistic at best, and they will recoup. So no voluntary working. But yeah, fundamentally, in relation to this query, it is open to an employer to rotate periods of furlough. Just make sure your minimum 3-week period is there, and make sure that if you seek to do that, employer communications must be clear. Expectations have to be concise and clearly communicated. And as I say in this slide, the days of implied consent for furlough are over. Implied consent was permitted right at the start whenever Boris Johnson said there was an effective lockdown, particularly for hospitality. Bars, restaurants were closing. There was no time to get express written consent, especially with a poor understanding of this new scheme, which was no criticism of employers. No one knew what it was. But those days are gone. There's been a huge amount of government information, guidance, practice directions in relation to furlough. So express written consent, which is clear, concise, must be obtained if we are rotating our staff members.